Hey everyone, it's Sam Bryant from Bryant Taylor Law, and this is Question of the Day, where we answer a real question that was asked by either a client or a prospective client. Before we get into it, Bryant Taylor Law is a business law firm. We help business owners start businesses, and we also help business partners resolve their partnership disputes. So today's question is, does a lease extension have to be in writing? In Florida, a lease extension does not have to be in writing depending on how long the extension is going to last. So typically, if you're in a residential lease, your lease will probably be a year. So the extension is usually the same amount of time that the original lease was. So as a result, if you have a year lease, then you have a year extension. The rule is if the extension is less than a year, it does not have to be in writing. If the extension is a year or more, it has to be in writing. Even though the rule does allow for lease extensions to not be in writing, assuming it's less than a year, in my opinion, every single extension needs to be in writing. This is because every lease is still a contract, and every single contract you have, regardless of how long it's supposed to last or how much money is at stake, needs to be in writing. If there's ever an issue, it's going to be very difficult to prevail or to get what you want if you have to prove that a contract has existed because of something that you've said to the other side. When you have a writing, it's all there in front of you. It's easy to prove, and especially if you're not the one doing anything wrong, then you're more than likely going to succeed whenever you have an issue with the other party. So when it comes to lease extensions, it is very important to understand that when the lease extension is for less than a year, it does not have to be in writing, but it should be. If the lease extension is for a year or more, it does have to be in writing. If the extension is more than a year and it's not in writing, if you have, let's just say, a term in there that you're arguing with the other side and you have to take that other side in court, you are probably not going to win because that lease extension will be considered unenforceable by the court because it was in writing. So one more time, and this is in Florida, by the way, if the lease extension is for less than a year, it does not have to be in writing, but it should be. If the lease extension is for a year or more, it has to be in writing. I hope you found that helpful. If you did, please feel free to like and subscribe to our channel. We come out with these videos on a regular basis. And if you ever need to talk to an attorney, we are based in Fort Lauderdale, and we have a booking link in the description, and our website is there as well. Hope you enjoy the rest of your day and stay safe.